So good evening, everyone. Welcome. My name is Birsha Odedar. I'm a lecturer here at the University of Essex Human Rights Centre and School of Law. We are here for our human rights speaker series today on rights-based litigation challenging the climate crisis. We are, of course, speaking today in the sort of shadow of COP26, where we know that, for example, that the pledges that countries have put forward take us to more than a 2-degree world, taking us into sort of dangerous climate change. And so the battle to kind of curb that is not just in terms of political activism, but also in terms of legal activism. And today we're talking about climate litigation. And some recent snapshot figures from the LSE have showed that the cumulative number of climate change cases has doubled since 2015. So between 1986 and 2014, there were 800 cases. And while in the last 6 years, there have been about 1,000 cases. These cases are from here in the global north, where we sit, or at least I'm sitting in the UK, where we've seen action against Heathrow Airport, net zero targets, as well as in the global south in places like Pakistan, India, and today we'll be talking about Guyana as well, where the first climate case was filed recently. And importantly, rights-based litigation has been an important aspect of this. Over 100 human rights cases have been identified globally. Sorry about this. Over 100 human rights cases have been identified globally, including in the US, and 29 of these were filed just in 2020. Human rights have been, of course, central to many seismic struggles, including civil rights battles and so on. So today we'll be talking about how this deals with the issue, how rights-based litigation can deal with the issue of climate change and tackle the issue of climate change. So we have 3 excellent speakers today. We have Dr. Annalisa Savaresi, Associate Professor of International Environmental Law at the Center of Climate Change, Energy and Environmental Law at the University of Eastern Finland. Melinda, and then we are really pleased to join by Melinda Janke, an international lawyer challenging the massive oil and gas production offshore in Guyana. In 2020, she won a case that cut ExxonMobil's environmental permits down from 23 years to 5 years. She's also representing indigenous youth in a climate constitutional case challenging Guyana's oil production based on a rights-based right to healthy environment. And finally, we have Richard Harvey. Richard is a barrister and legal counsel on the campaigns and actions team at Greenpeace International, where he's worked since 2014. He specializes in climate change and human rights litigation. So without further ado, the order of speakers will be Annalisa, then Melinda, and then Richard. You'll have about 10 to 15 minutes each, and then we'll have some time for Q&A. If you do have questions during the sessions, please feel free to put them in the chat. So Annalisa, the floor is yours.
Thank you very much, Birsha, for the invitation. It's great to be with you all. Indeed, this is a busy time. I am in Scotland presently, and it's fair to say that there is a lot of talk surrounding the enforcement and accountability gap in climate governance. So I guess my job with this afternoon is really that to set the scene in order for Melinda and the next speaker to really talk about these momentous cases they have been involved in. And the work I wanted to present to you today really builds on some of the published works that the audience may know. There is a special issue of the Journal of Environmental Law that is about to come up in the new year. And the research in it has already been presented in a number of fora. But what we did in this special issue was really to try and look at the big picture of what we call human rights-based climate litigation, which we define in the special issue as lawsuits that concern climate change that are based in whole or in part on human rights. So this is the piece that I just mentioned that I wrote with Joanna Setzer, who may be known to many of you because she is the litigation guru really at the Grantham Institute, and there's a wizard that has been compiling and analyzing all this climate litigation that exists globally. And what we did with Joanna was really to try and drill into the details and look at the numerous cases that are in her database and identify the ones that deal in whole or in part with human rights. And once we identified those cases, we looked at what is it that they do. And this is what I will be telling you today in this 10 minutes or so. So, we carried out our investigation in the first part of this year when there were 112 cases logged in the Grantham database of climate litigation. So at that point, the database had around 2,000 cases, and of these 2,000, only 112 relied in whole or in part on human rights. If we looked at the data today, the numbers would be larger. So one of the things that we did with Joanna was to compare the data between the two databases and find out what exactly were the trends in human rights-based litigation vis-a-vis general climate litigation. And here you can see that there is a large number of climate cases that have been filed since 2005, but there is a relatively small number of cases that rely on human rights on the right of this slide. What is more interesting is that the majority of these cases have been filed in the last 3 years or so. So we're talking about a very recent trend in climate litigation. The other interesting detail is that whilst the vast majority of climate litigation generally has been filed in North America, rights-based cases have been largely filed in Europe, followed by global South nations. This is perhaps unsurprising to those of you who are familiar with human rights and environment, case law and jurisprudence, because this is in line with general trends in this area. Who are the applicants in these rights-based cases? In general climate litigation, the vast majority of applicants are companies and governments. This is because climate litigation databases include both what we call anti-climate litigation and pro-climate litigation. In our analysis, instead of rights-based litigation, we only looked at pro-climate cases, and there is an explanation in the paper why we did that. So pro-climate litigation that's based on human rights is largely brought by individuals and groups, most commonly civil society organizations. And who do these groups target? They largely target states and public authorities. However, more recently, there has been an increased amount of litigation that deals or tries and target corporate actors also on the basis of human rights. So this is an interesting development, and I'm sure that others will elaborate on why this is the case. Why are human rights being used to target corporate actors? What has been the outcome of these cases? As I said already to begin with, we are talking about a relatively new trend in climate litigation, so not many cases have been decided when we're talking about human rights-based cases. It's fair to say that when compared with general climate litigation, human rights-based litigation is less successful on average, but as I already mentioned, the climate litigation database include both pro and anti litigation, so it's a difficult comparison to make because the general litigation includes cases brought by corporate actors against the state, as well as the kind of litigation that we're talking about here. What also we know in our paper is that in general, cases may have an impact, like the famous Juliana case in the United States, even when they're not successful, because they inspire similar litigation elsewhere based on similar grounds. The other thing that we did with Joanna was to look at what kind of arguments are embedded in these rights-based climate cases. And in order to understand this, we looked at the categorization of human rights obligations carried out by the UN Special Rapporteur on Human Rights and Environment. I'm sure that many of you already know that the UN Special Rapporteurs have written 2 reports on climate change, and the last of these in 2019 really tries to unpack the obligations of states vis-a-vis climate change under human rights law, as well as the responsibility of corporate actors. So we looked at these categories and typologies and understand which were the arguments that were being most used in climate litigation to date, making some predictions as to what arguments may be used in future. And for now, we notice that the vast majority of rights-based litigation targeting states relies on substantive obligations to adopt legislation in particular and to refrain from harmful activities. Not a lot of litigation concerns the enforcement of existing legislation yet, and not a lot of these litigation concerns procedural obligations to access to justice, to provide access to information, and so on. Even less litigation exists targeting corporate actors. And again, we engage in a similar exercise, and we notice that the vast majority of human rights-based litigation targeting corporate actors generally concerns a positive duty to reduce emissions. Very little litigation concerns the procedural responsibility to disclose emissions, consult affected parties, and provide access to remedies. Some of this litigation, however, also concerns the negative obligation to refrain from performing harmful activities, which is the other side of the coin of obligation or responsibility to reduce emissions. So what are the opportunities and obstacles to this litigation? Clearly, on the one hand, this is about raising awareness of the fact that there are human rights implications of climate action and inaction by states. And the ultimate gain is that to engender change in corporate and state behavior. The common obstacles to this litigation are, of course, the usual ones: the limits to the powers of the judiciary, the limits embedded in the legislation itself, and in particular in human rights, and the extent to which they are interpreted in a way to accommodate grievances associated with climate change. Some of these cases, as I said, have been successful, and some less so. So what did we conclude? And what is the takeaway point really from this bird-eye perspective on human rights-based climate litigation? Clearly, human rights law is being treated as a means to address the justice questions associated with climate action. And most importantly, that human rights do provide remedies, especially when no other remedies are available. And I'm sure others will talk in the details about what reasons they identified in order to base their complaints on human rights as opposed to other legal grounds. What I also argued together with Joanna in this paper is that human rights remedies are used as an interim gap filler many times because there's nothing else or nothing better that can be used in order to support the applicant's claims. And this is an important reflection for us to make today, because as I often say to whoever cares to listen, climate law is a relatively new phenomenon and it's still in its infancy. So as we develop the law and implement it, we're also identifying the gaps that exist within the law and the way in which they need to be filled one way or another. And human rights law quite typically performs this role in the environmental context in order to bridge the enforcement and accountability gaps in environmental law. Eventually, what this is also about is that need to engender a change in the legal culture, not only of the corporate actors and the governments, but also the judiciary and the legal professionals. So I do think that this is a part of a general movement whereby climate change is being mainstreamed across areas of the law. And here on the sidelines of COP26, for example, I engage in capacity building on human rights for climate negotiators and on capacity building for national human rights institutions on climate change. So you see, it goes both ways, and we all need to connect the dots between areas of law and understanding what each and every single one has to give to resolve this climate emergency in which we are living in. And I think I'll leave you with that, and I very much welcome any questions you might have for me. Thank you very much for listening.
Thank you very much, Annalisa. Well, without further ado, we'll go straight to Melinda then.
Okay, wonderful. Thank you very much. It's lovely to be on this panel and to be with very, very distinguished colleagues and friends. I'm going to talk about a landmark constitutional case, Thomas and Freitas, which is a fundamental human rights case, and it's brought against the government of Guyana, represented by the Attorney General. This is possibly the biggest climate change case in the world, and I'll tell you why. ExxonMobil says that it's found 10 billion barrels of oil offshore Guyana. Burning that oil would release more than 4 billion tons of greenhouse gas. So at stake in this case is 4 billion tons of greenhouse gas. Let me put it in context. We recently heard about the case of the century in France, Wonderful Victory, and that case dealt with 15 million tons of greenhouse gas. Thomas and Freitas is 286 times bigger than the French case. And to just compare it with a country, in 2020, the UK emitted close to 330 million tons of greenhouse gas. If Thomas and Freitas succeed, these two wonderful, courageous individuals will save the Earth from the equivalent of about 13 years worth of greenhouse gas emissions from the UK. So who are they? The first claimant is Dr. Troy Thomas. He's the Dean at the University of Guyana, and I've acted for him previously. In fact, last year I acted for him on a case, the case that cut Exxon's permits down by 18 years. So Exxon now has to apply for an environmental permit and get it by June next year, or they will have to stop production. The second litigant, Quadad de Freitas, is an indigenous Wapichan youth from the south of Guyana, and he states in his affidavit to the court that climate change affects his traditional way of life. The Wapichan people came from Brazil to Guyana at the end of the 18th century, and they own land in Guyana under collective titles that are absolute forever and protected by the Constitution. And because the Wapichan own the forest on their land, that means they own the carbon removal services of those forests. And of course, that has a value. Now, Thomas and Freitas, their claim is that the greenhouse gas emissions from Guyana's oil are incompatible with the right to a healthy environment. And Article 149J of Guyana's constitution says that everyone has the right to an environment that is not harmful to his or her health or well-being. And Part 2 says, the state shall protect the environment for the benefit of present and future generations through reasonable legislative and other measures designed to A, prevent pollution and ecological degradation, promote conservation, and secure sustainable development and use of natural resources while promoting justifiable economic and social development. That right was put into the Constitution following my legal analysis and lobbying during Guyana's constitution reform process 20 years ago. and it's in the fundamental rights section, so it's enforceable. Dr. Thomas's affidavit says that the oil will exacerbate the climate crisis, increase ocean acidification, and increase the harm to the health and well-being of Guyana's children. He says greenhouse gas pollution imposes a disproportionate burden on his children, and they will suffer the effects long after his generation has died. Mr. de Freitas' affidavit says that his spiritual health and well-being are closely connected to the forests and the savannas and their biodiversity. He says, "I live with nature around me, and it nurtures my spirit. Climate change affects me personally and makes it more difficult for me to survive and to live a traditional life." The legal basis for this case is the Constitution, and there are several provisions in there which are also relevant to this case. Article 36 of the Constitution, for example, states that the well-being of the nation depends upon preserving clean air, fertile soils, pure water, and the rich diversity of plants, animals, and ecosystems. And that is another article in the Constitution that I was responsible for. There is also provision in the Constitution for the best interests of the child to be the primary consideration in all decisions taken by public institutions, administrative authorities, or legislative bodies. Now, the case was filed against the state represented by the Attorney General, and the local subsidiary of ExxonMobil, Esso, has applied to join the case and has been added. So you have a university dean and indigenous youth against the state of Guyana, represented by the Attorney General, and the subsidiary of one of the biggest oil companies in the world. In fact, this is a third case in Guyana that involves the government and the oil companies. The first one was a case against the minister and Esso, Exxon's subsidiary, CNOOC, a subsidiary of the Chinese National Offshore Oil Company, and a subsidiary of Hess. The second case, was against the Environmental Protection Agency and Esso, and this third case is against the state represented by the Attorney General and now Esso. We've recently received the state's defense, and obviously I can't discuss the merits, but it is a public document and I can tell you what it says. The state of Guyana, represented by the Attorney General, does not admit climate change, does not admit ocean acidification, does not admit the greenhouse effect or the increase in global temperature or the link to fossil fuels. Paragraph 4 denies that the direct emissions from oil production are contrary to Guyana's nationally determined contribution under the Paris Agreement. And it denies that direct emissions of greenhouse gases make the environment more harmful to human health and well-being. The state also denies that the indirect emissions constitute a disproportionate interference with the environment and violate the right to a healthy environment under Article 149J. Do the emissions from Guyana's oil violate that right? That's the substance of the case. Now, the case isn't just high stakes, it's unique. As Annalisa mentioned, climate litigation so far, a lot of this has been concentrated in the north, the global north, the UK, Europe, North America, Norway, Australia, the big polluters. And their historic emissions have broken the climate system, raised the Earth's temperature, and made the ocean more acid. Thomas and de Freitas is different. Paragraph 12 of the state's defense says that data from Our World in Data shows that to date, Guyana's share of global greenhouse gas emissions from 1950 to 2019 is less than 1%. Guyana is not a big polluter, and this is a new and unique situation in human rights climate litigation. The case also raises some interesting questions of international law. Paragraph 14 of the state's defense says that in the context of international environmental law, equity connotes the right of developing states, such as Guyana, to pursue and benefit from the development of natural resources in the same manner that developed states did. And paragraph 17 of the state's defense refers to principles of equity and common but differentiated responsibilities. And the defense says these principles are woven deeply into the very fabric of every significant climate change treaty, including the United Nations Framework Convention on Climate Change, Kyoto, and Paris. And the defense also refers to the Stockholm Declaration and the Rio Declaration. And paragraph 20 says, requiring Guyana to abstain from developing its petroleum resources amounts to imposing an obligation that is equal to that held by the most developed countries and the industrialized developing countries, violates the principle of international equity, and is contrary to the principle of common but differentiated responsibilities, and would augur unwarranted economic and social costs for Guyana. Now, as I mentioned, the right to healthy environment is in the fundamental rights section of the Constitution, and Article 39 of the Constitution, which sets out the guiding principles, says that in the interpretation of the fundamental rights provisions in this Constitution, a court shall pay due regard to international law, international conventions, covenants, and charters bearing on human rights. So the state must look at international law when interpreting fundamental rights. However, it's only fair to point out that the state does say that no rights arise from the Paris Agreement. And in fact, paragraph 8 of the state's defense says, the prophylactic constitutional principle of dualism as distinct from monism is a characteristic of Guyana's constitution, so that the Paris Agreement, as is the case with all other international treaty instruments, create no legal rights for citizens and impose no obligations upon Guyana on the municipal plane until and unless they are given legal effect, being incorporated into Guyana's legislative architecture in the form of legislation. That as such, any non-compliance with the provisions of the Paris Agreement can only invoke state responsibility on the international plane. No coercive orders are available against Guyana in local courts to compel Guyana to implement the provisions of an unincorporated treaty such as Paris Agreement. The next step in the case is for the claimants to file a reply to the state's defense and to SA's defense, and that reply will be public once filed. So, using the human right to a healthy environment in the Constitution, Article 149J, and challenging greenhouse gas pollution from fossil fuel production. We have a legal system, applicable law, jurisdiction, and remedies are available. But I turn now to two situations where remedies are not available and where entities are able to promote greenhouse gas emissions, able to promote fossil fuel production without bearing any responsibility for their actions because they are outside of the reach of law. I'm going to look first at the World Bank and then at Global Witness, a British NGO. Now, the World Bank was set up under international law, and its origin is colonial. And I'm going to refer to Professor Matthew Craven, who says, to speak today of the colonial origins of international law is arguably no longer a standpoint of dissent or of a radical revisionism, but one which is situated in the center ground of accounts of international legal history. This is the history of the World Bank. It's an international financial institution, and in Guyana, it has behaved in a lawless manner. It provided financing for a project signed by a minister who was not a minister at the time. It has promoted oil and gas It has urged Guyana to change its Environmental Protection Act, claiming that the law is out of date and complex. As the person who drafted the law, I can tell you that's simply not the case. And in fact, when I did draft it, as a result of the provisions that I've put in, the oil companies must identify, describe, and evaluate the impact of their greenhouse gas emissions on the ocean, on the climate, and on the atmosphere. The World Bank has urged Guyana to switch to gas instead of renewable energy when Guyana's national determined contribution under the Paris Agreement from 2015 says Guyana will move to renewable energy by 2025, and so on. There are no sanctions against the World Bank. There is no court to bring them before, and therefore there are no remedies. And yet the World Bank's interference in Guyana is promoting gas, is promoting greenhouse gas emissions, which affect the right to a healthy environment. I close briefly now with Global Witness, who in 2020 produced a report saying that Guyana would obtain $168 billion from its exploitative agreement with Exxon. Those figures were false, and Global Witness were warned in advance not to publish those figures. Nevertheless, they did it. They also said that Guyana should allow ExxonMobil to take out the oil, undermining in-country efforts to protect Guyana from this exploitative deal. They recommended that Guyana should renegotiate and get 53 billion, when the in-country resistance said that you don't renegotiate, you strike down illegalities. And this report promising these billions was issued shortly before very high-stakes elections in Guyana, and was described as being a bomb, like being a bomb thrown into the elections fray. Undermining democracy and the rule of law? No sanction, no court, no remedy. Pro-greenhouse gas emissions in Exxon, and that leaves us with the difficulty of entities who do actually interfere in Guyana, but against whom there is no sanction. And this is an area that's often overlooked. Thank you very much.
Thank you. Thank you very much, Melinda, giving us plenty to ponder over. Thank you for that. I will, just before I pass it over to Richard, if there are questions for Melinda or Annalisa, please feel free to put them on the Q&A function, as and when, before we go into the Q&A section. Thank you very much. Richard, the floor is yours.
Thank you very much indeed. And two very tough acts to follow. I'll do my best. And if Katya, you're able to throw my slide up, that's great. Thank you very much. Advertising can damage your health, is my premise here. And when you look at the types of advertising that the tobacco industry were using back as early as 1946, and then the tobacco lobby coming to the US Congress in 1994, it is quite extraordinary that they got away with lying in Congress in 1994 and saying nicotine is not addictive, despite the 1964 US Surgeon General's report that it of course is a known carcinogen. And then when we look at what the oil companies have been doing, what the fossil fuel companies have been doing consistently since the 1950s, 60s, 70s, and 80s, they have known increasingly confidently that their products would cause dramatic environmental effects, and the potential problem is great and urgent. And they've known that for 40 years. Then as recently as a couple of weeks ago, they appeared in virtual testimony. Unfortunately, we didn't get such a nice, pretty picture as we did of the big tobacco, but they appeared and they lied to Congress too. They lied and said that they had never approved a disinformation campaign, whereas, of course, it is that they funded the dubious scientific claims that would undermine science that they already well knew to hold them liable for global warming. If we move to the next slide, it is indeed a human rights crisis. And we've had a look already at some of the areas of state responsibility. And the question is also, to what extent can corporations be held responsible? Now, with the Klimaseniorinnen case that was filed against the Swiss government in the European Court of Human Rights almost a year ago now, it is a year, the Klimaseniorinnen women whose average age was 75 or more, and who have experienced extreme heat effects in Switzerland, not a country known for being a particular hotspot, but the impact on women and girls of climate change is more severe than on men, and on elder women, the impacts of extreme heat are deadly. And the UN High Commissioner herself has stepped in on that case, filing an intervenor brief, an amicus curiae brief, in which she concludes that in accordance with international human rights law, states have a duty to take positive action necessary to limit warming to the greatest extent possible, consistent with the best available scientific knowledge. Not what they knew or thought they knew 10, 20, or 30 years ago, but the best available scientific knowledge today. So that is one major step which we believe is going to result in a favorable ruling. That's a terribly dangerous thing for a lawyer to claim in advance, but we do believe that this case is going to be given extremely serious consideration, let me put it that modestly, by the European Court of Human Rights. And then, to what extent can corporations be held to account? Well, we've heard already a little about the Orgenda case, the greenwashing case that was brought by Milieu Defensie, that's Friends of the Earth in the Netherlands, against Shell, resulted in an order in May of this year, ordering Shell to reduce its CO2 emissions by 45% by 2030. That's 45% compared to 2019, holding Shell responsible for both corporate and consumer CO2 emissions. So it's what the user emits, whether it's domestically or internationally, and requiring Shell to respect human rights, holding also Obiter that other companies have the same obligations as Shell. They too are responsible for reducing CO2 emissions. We can move to the next slide, please. That happened in Shell's Royal Dutch backyard, as you might say, and this also is in Shell's Royal Dutch backyard in Rotterdam. On the 4th of October this year, a Greenpeace ship blocked the entrance to Shell's refinery and towed banners there calling for a ban on fossil fuel advertising. Why advertising? Well, for the very good reason that cigarette companies are no longer allowed to advertise their wares in at sports gatherings. They're no longer allowed to have big public adverts up around the place. Yet fossil fuel companies face no such ban, while they do present at least as serious a health risk to the consumer. And their advertising is not exactly honest, as we'll see when we move on. If we could take the next slide, please. The climate crisis is a health crisis, as Mary Robinson said the other day at COP26 in the first ever health pavilion that they have had at a COP. And she said very clearly that a clean, healthy and sustainable environment is indeed a human right. And she praised the Human Rights Council, which, as you probably know, recognized just a few weeks ago for the first time the human right to a clean, healthy and sustainable environment, and also established a procedure for having a special rapporteur to promote human rights in the context of climate change. You may have heard of Ella Adu Kissi-Debrah, the 9-year-old child who died and on whose death certificate originally were the words acute respiratory failure and severe asthma. Her mother, a teacher and a very, very courageous and determined woman who'd worked for many years with health professions, knew that this was not enough. And together with Sir Stephen Holgate, specialist in asthma, air pollution and respiratory medicine, she worked with some of the finest lawyers in the UK at the firm of Hodge, Jones and Allen to present incontestable peer-reviewed science to the court investigating the cause of Ella's death. The coroner found air pollution was a significant contributory factor, and that between 2010 and 2013, Ella was exposed to levels of nitrogen dioxide and particulate matter in excess of WHO guidelines. The principal source of her exposure was traffic emissions, and the coroner amended her death certificate to incorporate air pollution exposure as the cause of death. And he also noted the failure to address unacceptable levels of nitrogen dioxide, the failure by the government to address that, the lack of public awareness and the inadequacy of information provided by healthcare professionals to patients and carers. And in doing that, he exercised a very rarely used power that coroners have to order national and local governments departments, health professional organizations and medical training experts to respond to his findings with a program of action. And each of those departments and organizations has indeed done so. In the World Health Organization has already noted that 4.2 million premature deaths occur per year on a global scale due to air quality. So this is not just about deaths and appalling individual suffering. This concerns the quality of life impacts on the entire social system. It speaks about truth, speaks truth to judicial power, in this case, the normally limited power of a coroner's inquest, but it also, what makes this a very important piece of strategic litigation is that it mobilizes people to respond. In the middle there, you see a photograph of Vanessa Nakati. Vanessa, 24 years old, Ugandan woman, decided that she would take up the challenge inspired by Greta Thunberg and started her own climate strike in Kampala. And as she puts it, you cannot adapt to lost cultures. You cannot adapt to lost traditions or lost history. You cannot adapt to starvation. You cannot adapt to extinction. And you can't greenwash it away. Those are my words, the last ones. And if we just move to the next slide, you'll see what I mean by greenwashing. There's a couple of great organizations, one called Badvertising, the other called Ad-Free Cities, and they've just posted some of these real and not so real, and perhaps even surreal advertisements. On the left, EasyJet claiming destination zero emissions. Give us a break. On the extreme right, life is so much better without restrictions, says Land Rover. And just to its left, Spanish speakers amongst you will have noted, no cojas el metro, don't take the metro, buy one of our SUVs, says Nissan to the Spanish audience. And a spoof ad in the midst of those, EasyJet, raging wildfires from $22.99. That's really the difference between the reality and the glossy version that is presented to us by the advertising agencies. Moving to the next slide, we've heard a little already about the Clima Seniorinnen. The Portuguese youth against Portugal and 32 other Council of Europe countries was filed over a year ago with the European Court of Human Rights. Wise heads like mine shook themselves and said, nah, that's not going anywhere. You can't expect them to accept a case without exhausting your domestic remedies. Well, I'm never happier than being proved wrong. The court did not just sling them out on their ear. It said to all 33 Council of Europe states, you've got to answer. If you want to raise the question of exhaustion of remedies, go ahead and raise it, but we're not going to throw it out. And by the way, you might also want to see whether or not a claim that they had not brought, which was under Article 3 of the European Convention, namely the torturous impact on quality of life that results from climate change. You may want to address those issues as well. An extremely interesting invitation. Greenpeace Nordic, and I've been working on that case for almost 6 years now, and Nature and Youth, the People versus Arctic Oil case, that also we have sent an application to the European Court. We're waiting to hear back from them after Norway took the position, the Norwegian Supreme Court took the position that although the oil, 95% of oil that is extracted in Norway is exported, it's not the responsibility, the emissions from that oil is not the responsibility of the Norwegian government. So it remains to be seen whether that view will be upheld. And finally, Vanuatu, as you may have seen, is seeking the advisory opinion from the International Court of Justice on the responsibility for taking action to curb climate change. I don't know how I'm doing for time. I should probably wind up pretty quickly. So if we just go quickly to the next, you'll see my idea of the Trojan horse of net zero arriving at COP26 to the delight of the fossil fuel corporations. And we all know, I think, don't we, that the promises of net zero tend to be specious, unenforceable, and frankly dishonest. And Greenpeace and others are calling for a ban on fossil fuel propaganda through the mechanism of an environmental, a European Citizens Initiative which requires us to raise 1 million signatures by this time next year. I'm confident we're going to do that, but anything you can do to help us on the way. Sadly, of course, citizens like myself are not in a position to register their votes on this. So the final slide is simply one that invites you to offer your questions, suggestions, and even objections. I think there is a final slide which has the point that Ms. Nakati was making to the COP, that the Global South is not on the front page, but it is on the front line. I'll end there. Thank you.
Thank you, Richard, and thank you to all our speakers. We do have questions, so I will start to relay those to the panelists. And also, if you do have further questions, please put them in the Q&A function, which is in the bottom of your Zoom screen. Before I do that, I did want to acknowledge, especially our students who are who have joined today. Part of the reason why we had this panel was that we had a lot of interest from students, undergraduate students, and some postgraduate students to have an event like this during COP. And so they really wanted to be inspired by the work of lawyers such as yourselves to tackle the climate crisis. So to the students out there, please do get your questions in as well. I'll start with some questions. I'll start with a round of questions that have already come in. Some of them are specific to specific members. So firstly, to Annalisa and also to Richard, actually, Engin Firat, who's a master's student here at Essex, asks about the European Court of Human Rights and some of the procedural hurdles that are there, and what you think of the promise of tackling climate change is because of these procedural hurdles. Secondly, a question for Melinda. Melinda, you mentioned about the World Bank. We've had some comments already about the World Bank. A question from Judith Bueno de Mesquita, who's also a colleague here at Essex, about the role of the World Bank. How can we understand or account for the World Bank position? Is it just a sort of outdated neoliberal position? Is it something coming from Washington? Is there any intimation of corruption? And perhaps most importantly, like what do you see that can be done? Obviously, you were saying legal routes are very limited within the country. And perhaps a general question to all panelists, and this comes from Andrew Fagan, the director of the Human Rights Center, on the significance of climate activism on climate litigation, which was touched on by all of you in different ways. For example, do you think the high-profile actions such as Extinction Rebellion here in the UK and elsewhere are somehow incompatible with and harmful to climate litigation, or whether such direct action is ultimately beneficial for climate litigation? So we'll start with those three, and then I'll come back for another round. Whoever wants to go first.
Happy to start. Thank you, Bersha, for those questions. Now, about access to remedies and procedural hurdles. I'm sure people in the audience have heard of the decision of a Committee on the Rights of the Child in the famous petition lodged by Greta Thunberg and other minors, at the point at least, against a number of states before this UN body. Now, there has been a lot of talk about this decision in recent weeks, and the summary of the whole story is that basically the committee expressed sympathy for the arguments put forward by the applicants, but at the same time refused to process the complaint on procedural grounds because the applicants had not exhausted domestic remedies. So the situation is similar to the case before the European Court of Human Rights that Richard has mentioned, but at least so far the European Court has not thrown out the case but of course, the case is yet to be processed formally. So we don't know, they may still do that. So what does this tell us about rights-based litigation generally? I think these cases are testing the ground, and the applicants are trying various different strategies in order to obtain a decision in the case of a committee or a ruling in the case of a European court. I understand why these human rights bodies are reluctant to not so much bend, but relax admissibility rules that have been operating for a long time in the face of a climate emergency. There are good arguments why these rules should be relaxed, but I also understand why these bodies may want to be conservative in order to have better control on what kind of cases are put to their attention. What I would say as a hopeful note is that there are other cases before the European Court of Human Rights where domestic remedies have been exhausted. There is the Norwegian case that has gone through all the levels of judgment and all the way to the Supreme Court. And there is the Swiss case, the Klima Signorinen case. So even if the children case before the European Court of Human Rights is eventually thrown out, we have other cases that at least procedurally will satisfy the court that it can go on and consider the merits if it's willing to do so. But it's just a long game. And I know that this is frustrating because we don't have time. Nevertheless, this is one of the limitations of litigation. And I was talking a little bit about this in my presentation. There are limits as to what these bodies can do. And the hopeful sign is that the European Court at least has expedited these climate cases. So we may have a decision faster than we normally get one, but it's still a long game that we're looking at.
Richard, did you have anything else to add for that question, especially on the European courts and also on activism? And then we'll go to Melinda.
Yeah, on the European Court, I think Annalisa's really encapsulated it perfectly. The only thing I would add is that there have been signs in the last sort of 12 months where members of the court have given public utterance to the importance of climate change. That they have noted that the explicit term environmental justice is not to be found in the European Convention. Nevertheless, the court has addressed environmental issues in the past, and the reading between the lines, there, if not an open invitation, certainly a suggestion of a favorable wind that they realize it's time they said something rather than not saying anything. Because one of the great points that our opponents have taken in Norway and Switzerland has been to say, well, there's nothing in the European Convention about it, so we don't need to address that issue, do we? So I think the judges themselves, some of them at least, find that an embarrassment. On the question of high-profile actions of groups such as Extinction Rebellion, I'm reading Andrew Fagan's words there. We, as I think is well known in Greenpeace, are advocates of non-violent direct action, and we can be pretty damn direct. There are some who want to be even more direct. Does it hurt? So far, I've not seen any suggestion that it does. Some actions are smarter than others. Some are designed to cause disruption. And I'm sorry, disruption is sometimes a necessary part of progress, because otherwise we are going to be disrupted beyond belief. by climate change. But in general, I'm an activist, have been all my life, and I've never been happier than the last 7 years that I've been working at Greenpeace as an activist lawyer. Over.
Thanks. Thank you, Richard. Melinda, on the World Bank question.
Yes, I think the question was, is the World Bank out of date? I think the answer to that has got to be absolutely yes. As I mentioned earlier, the World Bank was established under international law. This was done in the 1940s at the end when colonialism was beginning to disappear, at least the formal institution of colonialism. The bank was hurriedly set up at that point. And the development idea of the World Bank actually comes out of the civilizing mission that is a fundamental part of colonialism. So you have this institution that is now going to continue the mandate by which the European countries, North America, former colonial countries and new colonial countries will continue to extract the resources of the rest of the world. Second, and this is, there's another issue here, which of course, this is a completely undemocratic institution. It's not accountable to anybody. It's sort of accountable to the executive directors, but half the time I think they don't really know what is going on. I mean, I bet you anything that the executive directors, when they approved the Guyana World Project, did not know that there was no Minister of Finance who could legally sign that agreement, because the executive directors would not countenance unlawful activity. The other issue here, coming back to this idea of it being out of date, is of course, this is an institution run mainly by economists or with an economist's mindset. And it's more like a religion, a religious institution, because here you have people who believe in perpetual growth on a finite planet. Now, you're not going to have perpetual growth on this planet. And we have seen the results of that: biodiversity extinction, climate, I don't know why we call it climate change. We should call it greenhouse gas pollution, which is choking the earth to death. And we are still hearing these ludicrous arguments about, well, you know, we need to have a just transition. No, we need to stop fossil fuels right now. We hear these ludicrous arguments, for example, in Guyana, that gas will be a transition fuel from the little heavy oil generators that we have, which don't produce enough electricity for the country anyway. And we're going to have this bridge fuel called gas before we go to renewable energy in a country that has sunshine every day, massive rivers, and there has absolutely no need to have gas. But this is a mindset that is still destroying the earth. We see the World Bank trying to persuade Guyana to change the law to allow flaring, and then marketing this as, well, Guyana can join the World Bank Zero Flaring Initiative, which is not in fact a zero flaring initiative, but is a way of allowing ExxonMobil to flare for until 2030, because that's when the zero flaring thing kicks in. We also see in a World Bank project, ExxonMobil's lawyers being hired to dismantle the laws in Guyana. And we wrote to the World Bank president and we said, what is the connection between these lawyers and the World Bank staff? Because we noticed that these lawyers also say that they're the preferred lawyers when the World Bank is doing certain development work. We want to know what is the connection. There was no response from the World Bank president, but we were told later on that these lawyers had pulled out. So I think what you're seeing here is an assumption that this institution has the right, the power, the mandate, whatever, to direct to people in this country 4,000 miles away or however far away what should happen. It's anti-democratic, it undermines the rule of law, and it is definitely out of date. And I think possibly at this stage the best thing to do is to stop it, shut down the World Bank, stop wasting taxpayers' money, and let people in their own countries hold their own governments to account, rather than these people who fly in and fly out and don't answer to anybody in country for the mistakes that they make.
Thank you. Thank you, Melinda. And thank you all the panelists for your responses to those questions. I'll follow up with another round of questions, if you don't mind. So we have, firstly, a question from Luke Daniels, which follows directly from what you've said, Melinda. Luke Luke Daniels, who's president of the Caribbean Labor Solidarity Group, and he asks, what are the chances that rich countries pay to keep the oil in the ground for countries such as Guyana, poorer countries such as Guyana? Perhaps looking, previously there was the example in Ecuador with the Yasuni ITT initiative, where I think deforestation was around the same. The Ecuador essentially asked the international community for money to stop extractivism, and that didn't come forward. That was maybe 15 years ago now or something like that. So perhaps, is there any more appetite for something like that based on some of the issues of equity and climate justice and so on? Secondly, a question from Daniela Sanchez, and she asks about the role of judges, whether the judges are really able to understand the magnitude of the crisis that we face. Annalisa kind of touched on this point towards the end around capacity building, but all of you may wish to comment on this. And Melinda, it would be great to hear your views from Guyana as well. Judges, also lawyers, whether lawyers are understand the magnitude of this crisis. And finally, a question from Jude, around success. What did you mean by successful climate litigation? Perhaps that was stemmed from Annalisa's presentation, but it's a question for everyone who's doing strategic litigation. What do you count as success? So happy to go with whoever wants to go first, Melinda or Annalisa. Annalisa, do you want to go? We'll go in the same order,
Yes.
maybe. Yeah.
Happy to do that. So let's just say I will just stick to a couple of points. You're quite right, Birsha, when you're talking about the idea of a payment for keeping oil in the ground or forest standing has been around for quite some time. It's fair to say that international cooperation has not risen to this challenge. The idea has struggled to take off. I don't know if we can safely say that Glasgow has made any difference. There's been a lot of talk in these days about a renewed initiative on stopping deforestation, but we really have to better understand the details. What I would say is that the experience of Brazil gives us some pause. Brazil was very successful in the last decade in requesting and striking agreements with developed countries like Norway that passed on to Brazil non-insignificant amounts of cash to stop its deforestation. And the disaster in the Amazon is there for everybody to see. So I think we have to be skeptical about these dealings that don't result into any concrete emission reductions. We really have to be careful not to throw resources at hopeless experiments. At the same time, I think it's important to try. It's very important that to try, and hopefully lessons have been learned from this experience with Brazil. But I don't think we should focus on buying our way out of this problem, if you see what I mean. We should really think about doing everything we possibly can to equitably empower developing countries to do what it takes for them to get to net zero like everyone else. And I know this is really hard to do in practice, but I think we really have to focus international diplomatic efforts like COP26 to really do better than what we've done so far. Judges. There is a lot of variety in the judicial profession. I would say some judges around the world have woken up to the urgency and really stepped up and even gone well beyond their comfort zone in adjudicating climate cases. Our judges instead have been very conservative. The Norwegian judges that have been mentioned could be named as an example. I know some Norwegian colleagues that may disagree with this assessment, but I do think that for an outsider to the Norwegian legal system, what they have done in the oil and gas field licenses cases seems very unambitious. And I am very grateful for the work Melinda is doing, because it shows that it can be done and it should be done. So I know that there is a lot of activism around this. And I do think that these positive precedents really show that there is a way for the judiciary to step in and show the way to the legislature, because this is what we eventually need. We need the executive and the legislature to stop this kind of processes, new oil fields, new gas fields. We don't want any more of that if we're serious about net zero. And this is really the judiciary coming in at a very late stage in the process. We really want these projects not to go ahead in the first place. We want even legislators to outlaw this kind of activities. And, you know, we're phasing out cars. We should phase out oil and gas. And this is really what needs to happen.
Thank you, Annalisa. Richard, do you want to?
I'll just come in quickly. On the question of judges and climate cases, definitely we've come a long way. But then on the other hand, I did qualify at the bar 50 years ago this month. So I would never have trusted a single judge back in the day. But as you get older, some of them become your friends. And some of them really do become environmentalists. And we've seen the most classic example of that is Brian Preston in New South Wales, Australia, one of the finest environmental judges, and who's delivered some of the best judgments of anybody so far. I've always had the point that you can never trust politicians, because all they care about in what they think about as the long range is getting re-elected at the next election. Judges, on the other hand, hopefully have children and grandchildren, or nephews and grandnephews, and nieces, sorry, and they are more minded to look to future generations than other decision makers in the political sphere. When it comes to paying to keep it in the ground, this is the most complex question of all, because when it comes to, again, you instance Norway quite correctly. They have this massive sovereign wealth fund gained from oil and gas, and they are putting their money where they would like their mouth to be seen to be, in allegedly supporting Brazil's attempts to prevent deforestation, which have been absolutely non-existent and disastrous. And so Norway claims the credit for carbon offsets by failing to stop the carbon emissions in Brazil. They apparently went looking for someone in Indonesia that they could give the money to, but they couldn't find anyone who wasn't already obviously corrupt. And so the money didn't go there. So you've got corruption at both ends of this equation. And how you get the payment that is desperately needed to protect Pacific Islanders whose countries are simply going to disappear, how you get that money sorted to at least provide the basic bulwarks against the extreme weather events of which they are undoubtedly going to be victims time and time again. That is something that is beyond this humble lawyer's ability to figure out, I'm afraid. That's what's got to be done.
Thank you. Thanks, Richard. Melinda?
Yes, thanks very much. Excellent question, Luke. Thank you for raising it. I mean, I think morally, of course, the so-called rich countries should be paying Guyana to leave the oil in the ground. I just want to perhaps refine the question a little bit, because Guyana is not a poor country. Guyana is actually an extremely rich country. It's the people who are poor, and they are poor because of decades of mismanagement of the resources by successive governments. And that is why when we talk about payment, we're saying that the money should go to the people, not to the politicians, not to the government. And there was a letter that went to the president just before COP began, stating that money for Guyana's forests should go to the people, because it is the people who own those forests. It should not go to the government. And that where those forests are on Amerindian lands, the money should go directly to those Amerindian landowners. The lands are held by collective title. And so the money should go straight to those communities, not to the government, not to any NGO, because we have a serious problem in Guyana with, for example, the European Union and states giving money to NGOs who do not represent anybody in Guyana apart from their membership, because Amerindian peoples have self-determination. They speak for themselves and they have their own elected councils. So you have this conflict funded by very, very well-meaning people, but you can't go into someone's country with your own ideas and think, well, we're going to do the same thing here that we do at home. Another issue with the money is, once it arrives, the risk is it goes on vanity projects. It goes on things that have nothing to do with forest protection. And if you read paragraph 28 of the defense of the Attorney General in the Thomas and de Freitas case, it says the funds received by Guyana for maintaining its forests have been used to implement various social and economic improvement initiatives, including the Amerindian Land Titling Project, the Access for Hinterland Poor and Remote Communities Project, Micro and Small Enterprise Development, the Cunha Canal Rehabilitation, and so on. So the money is not actually going into forest protection. Coming back to Norway and this Sovereign Wealth Trust Fund, I have a problem with this, because this is not money that was made in a legitimate way. This is money made from fossil fuels that stole the future. This is what is causing the climate system to break down, is making the ocean more acid, is causing sea levels to rise, and is making the ocean hot and making the planet hot. All of that money should be used to undo the damage from fossil fuels. All of the sovereign wealth funds, that's what that money should be used. And we just simply apply the principle, polluter pays. This is not rocket science. This is what we should be doing. I want to make one comment about judges. Judges are going to make decisions based on what the lawyers put in front of them. And so the legal profession has a massive duty now to make sure that the evidence is put before the courts in every single country and that the arguments are made. But I would also say this is a defining time in history for lawyers. Whose side are you going to be on? Are you going to be on the side of the fossil fuel sector, or are you going to be on the side of the people who want to see the Earth survive? We're on the edge of biodiversity extinction. We know all the problems. This is a moment when lawyers have to decide for themselves, which side am I on?
Thank you, Melinda. Lucid, as always. I think even though there's about 8 or 9 minutes left, we have answered questions, and that was a really sort of good moment, I think, to end. We're just thinking about which side those in the legal profession will be on, a sort of line in the sand moment. So I'd like to thank all of our guests today, Annalisa, Richard, and Melinda, and just like to thank the audience as well for all of the all of your questions and your engagement. It was really inspiring, as well as very kind of knowledgeable kind of presentations that were given by everyone. So I'd really like to thank you all for taking the time this evening, and thank everyone for coming along. Yeah, with that, I think we can just end today's session. Thank you very much.
Thank you very much.
Thank you.
Bye-bye.
Thank you, Barsha, for chairing.
Thank you very much.
Thank you, everyone, for joining.